Now the court has disposed of the application under Order 21, Rule 57, 58 concerning objections. Okay? That means the court has said that here the objections are not tenable and objections raised are absolutely frivolous, and the decree passed cannot be stayed and or set aside. There is no ground set out. Then the property should be put up for sale. That is Order 21, Rule 64. Okay? Order 21, Rule 64 देखिए, sale, यहाँ पे sale होता है. That is the next step. That is the next step, sale का. Sale is normally by public auction. Please see Order 21, Rule 65. Or any manner prescribed. Some judgments of the Supreme Court, High Court say that public auction agar possible nahi hai, it can be by private treaty. I mean, people are not coming forward, or maybe a small property, it is not worth advertising for sale. Too much of money will go in advertisement in the newspaper, official gazette mein dene ke liye. The court may dispense with, the decree holder has to make application. Your Lordship be pleased to permit sale by private treaty, private parties. So otherwise, in a big property, big cases, proclamation of sale by public auction, and by issuing proclamation of sale in newspapers, Order 21, Rule 66 check कीजिए आप. ये proclamation होता है इसके अंदर. So why proclamation? Proclamation should be granted. The decree holder has to file affidavit and giving full particulars. That is Order 21, Rule 66, subclause 3 के अंदर. And notice will be issued to judgment debtor. Order 21, Rule 66. 2 clause E check करो उसके अंदर. Clause E के अंदर last line कहता है कि notice must be issued. Or the court can dispense with the notice also. Generally, notice is given. Then timing of the sale is prescribed under Order 21, Rule 68. Time and date, place. Adjournment and postponement of sale is 2169. This is with a view to enable the judgment debtor to arrange for money and deposit. See, one more opportunity is given to him. Before the knockdown. Knockdown means finally calling the sale. Now, in the sale process, the person, the decree holder normally himself cannot purchase the property without the permission of the court. Order 21, Rule 72. If there are no sufficient purchasers in the market, not come forward, the decree holder can say, my lord, I may be allowed to purchase it. Normally, he is not allowed to purchase. Similarly, a mortgagee in a mortgage suit cannot say that in a suit for foreclosure, I will purchase it. Or in a redemption suit, under the provisions of Order 34 and Section 69 of the Transfer of Property Act, Mortgage Suit 69 to 78, various. So even the mortgagee under Order 2172A has to take permission. And there's a restriction, court officers cannot purchase the property. Order 21, Rule 73. Court officer, learned judge, court receiver, the Shereshidar, judicial officer, any clerk, any person of the court officers, any public servant has no right to purchase it. Order 21, Rule 73 lays down the procedure. Okay, please note that these are the restrictions on sale which cannot be done. Then how the how these movable property sale is Order 21, Rule 74. Procedure for sale of movable property, agricultural produce. In a paddy land, paddy is put up in the next to the land itself. You have to go. Sale must take place there. It cannot be brought to the court. It's a very hardship to the poor farmer. Facilities are given to him. You agar chawal, gehu, whatever is sought to be ganna, in the field ke andar rahega, so auction sale should take place there normally, unless the court dispense with it, cause other. Then growing crop ke andar 2175, the special rule, the crop is there, the court will say that you're near the crop only. Then procedure with regard to negotiable instrument sale is 2176. How the shares in a corporation are sold. Then suppose, for example, you are a successful bidder, you have to deposit 25% of the sale money immediately. Auction sale mein aapne siya, I am purchasing the property for 1 crore. 25% you must deposit. That is Order 21, Rule 84. 25% immediately bharna padega. That is the deposit money. And the remaining 75% should be completed within 15 days. Otherwise, what will happen? The money will be forfeited to the government. Default. Order 2186 कहता है कि the deposit money stands forfeited to the government, and the court will start resale procedure. Advertisement in newspaper. Resale procedure is 87. These are all the steps very taken. Then one more opportunity is given to the third party under Order 21, Rule 89 and 90 for setting aside sale. Mean the property is sold in execution. यहाँ पे sale हो चुका है. That is Order 2184 हो चुका है. 84 के अंदर deposit money हो चुका है. And default is not committed. But the sale is not, the final certificate is not given. The third party or even the judgment, the defendant, that is the decree, the judgment debtor can come before the court, make an application for setting aside the sale. One more final opportunity, see that here, under Order 21, Rule 89. By depositing the money, that means the object of the court is the real owner of the property should not be deprived of his property. If he is able to arrange the judgment debtor, an opportunity should be given to him. Then in that event, a third person claiming the property can come forward. Ye property meri hai. Why was he keeping quiet for so long? The court will say deposit 5% money, purchase money. The Order 2186. Because this is a penalty for coming belatedly. You cannot going to have a cakewalk. Court will say deposit 5% money before challenging it. And he has to deposit proclamation money also. Advertisement के पैसे भी भरने पड़ेंगे. Mean either the person claiming to be the heir, legal representative, judgment debtor, or a third person. For coming belatedly, the penalty is 5% money you have to pay and also meet the proclamation charges. This is one proceeding for setting aside, for coming belatedly. The second option for setting aside sale is Order 21, Rule 90, where a gross irregularity of fraud is committed. Fraud के particulars देने पड़ेंगे आपको. the decree holder has played a fraud. That means he is attaching property of XYZ and he made a false declaration, false affidavit, whatever may be. Grounds are the irregularity is not a general irregularity. It must be a serious irregularity. Newspaper publication के अंदर गलती हुई, that is not a ground. Mean fraud mean what? During the pendency and completion of the sale, the decree holder has entered into an agreement of sale with third parties or taken a loan from the property. That is a fraud he cannot do because the sale is not confirmed as it. So the decree holder should not do any overt act. So in that event, if the court is satisfied, final opportunity here under order 2190 to set aside the sale on the ground of irregularity and fraud. Please note that here. Now 21, the order 2191A says the purchaser who has purchased the property under order 21 rule 84 by depositing money, he took inspection of the court record. Then he comes to know, my lord, the judgment debtor does not have a saleable interest. So the sale be set aside. I mean, like we gave the case of the Supreme Court in the earlier case of in a flat in a cooperative housing society attached. The Bombay High Court had stopped the sale on the ground that here a member of a society has no saleable interest under section 31 of the Cooperative Societies Act, which contention was not approved by the Supreme Court later on, which we later on. So in any property which may be discovered, the judgment debtor has no saleable interest. He has only the property attached is not his absolute property. It may be a joint family property. It may be a property which he is claiming as an executor under a will. The will is not probated. So he doesn't have a saleable interest. So I do not want to, the sale may kindly be set aside.
Sir, but in this scenario, should this objection not be taken at the time when suit was going on?
No, this is a purchaser's right. Where was the purchaser at the time? When the suit was going on, purchaser was not there. No? Purchaser is coming in auction sale. It's a third party.
Yes, sir. Yes, sir. But sir,
third party.
But sir, then judgment debtor
is an auction purchaser.
But sir, judgment debtor having no saleable interest is something what court should have seen at the very first instance.
If the court has made a mistake, the judges are also human beings. They make mistakes. That is why the matters go to Supreme Court. Appeal, revision, everything. So subsequently, section 60 is very complicated. Sometimes you overlook it. So when there is not a saleable interest, sometimes the trial court judges are over busy with matters, and they pass the orders believing under the impression. Sometimes many senior advocates make also misleading statement before the court, and the courts get carried away. Then you come to know that this submission is wrong. Ultimately, you discover it. There are many such cases come before the court of law. Sometimes lawyer misleads it and the judge misunderstands it. Some mistake take place. That is how it is. You discover. The purchaser comes to know only when he deposits the 25% money. He did not know the entire proceeding. So after depositing 25% money, he takes inspection from the record. He is lawyer. So after ascertaining his advice here, see this property which you are purchasing in auction, the defendant decree, the judgment debtor does not have a saleable interest. So prior to the judgment of the Supreme Court, in the society's case, which was the case I gave you ratio, Shah's case, What was the name of Mr. Shah? 1975 Supreme Court. In a flat in a cooperative society was attached. Isn't it? Ramesh Shah's case. Huh? So the Bombay High Court attached, stopped the execution. So at the time, the lawyer would tell that yes, under the Societies Act, shares cannot be, the share of a member cannot be purchased. So prior to the year 1974, that was the law. In fact, judgment of Justice Dima Dalal clearly said that a member of a society, cooperative society does not have interest in the flat. He doesn't have saleable interest. He can only occupy. So prior to 75, the lawyers must be advising here. Yes, he doesn't have saleable interest. After the Supreme Court judgment in the year 1975, now the member has been held to be having saleable interest. A member of his, the shares can be attached. Okay, that is how the application can be made and attached. Then once this process is complete, order 2195 ke andar delivery of the property is given to the judgment debtor. Okay. But if in case any suit is filed, now please note that here. Now under order, the provisions of order 21 rule 92, a third person normally has no, between the same parties, subclause 3 says order 21 rule 92, subclause 2 chakra, no suit shall lie, be brought by any person against such order. But a third party, sub rule 4 chakriya, a third party may challenge the judgment at a title by filing a suit against the auction purchaser, decree holder, judgment debtor, necessary parties. So the property, suppose a benami, the judgment debtor is only a benamidar. A real owner is sitting in America. So he comes down from America to see the property has been attached. He will say that I am the real owner. I have paid the consideration. So your lordship may kindly set aside the sale. So that he has a right to file a suit under 2192 subclause 5. Now when you see, when in that event he should join whom as a parties? The decree holder, judgment debtor as well as the purchaser. So the provisions of the order 21 rule 29 are also to be complied with. 21 rule 21 Jakaro, order 21 rule 29.
Sir, suppose a person's while execution of a decree, suppose the person's land is wrongfully, means the land is itself wrongfully attached. Then what will be the remedy?
Remedy order 21, 57, 58. Say property not attachable.
Okay.
It is not my property. Here third party, see that is the stage given in the execution proceeding. The stages for filing a suit is order 21, rule 57, 58, then order 21, rule 92. That is the person. That is before sale. This after sale is a 2192. Then you can apply for a stay order here. And section 65 भी check करो आप. Section 65 Mansi, please. The way the immovable property is sold in execution of a decree, such sale has become absolute. The property shall be deemed to have been vested in the purchaser from the time when the property is sold and not from the time when the sale becomes absolute. Now this is subject to order 21, rule 92, subclause 4 and 5. Section 65 is subject to order 21, rule 92, subclause 4 and 5. 4 and 5, the court can set aside the sale on the ground that the real owner is a third party. So there are 3-4 innings given to third parties here. That is, we learned garnish proceeding ke andar he can file a suit, isn't it? Garnishi ke andar third party can file a suit. My property has been wrongly attached. 2146 A, B and C. Then order 21, 57, 58 में सीखा आपने, isn't it? यहाँ पे भी सूट फाइल होता है. Order 21, 57 check करो again. After attachment, when attachment is determination, the court 57, 58 के अंदर adjudication of a claim, sub rule 5, the suit is filed. So 2 suits here. Third suit is order 21, rule 92 sub clause 4. So 3 types of suits are filed in execution proceeding, which normally does not allow suits, which is a bar under section 41. 41 is a bar against the defendant cannot file a same suit, and his children cannot file a suit. And similarly, an assignee claiming under the judgment debtor cannot file a suit. A third party who is not connected, who is not claiming a right at interest, can file a suit. I gave you an example. You are a defendant is a broker in Bombay against whom decree is passed. And gentleman in America wanted to purchase property in Bombay. He deposited 1 crore in the account of the broker. So that property has been attached. The third party can file a suit under the provisions of order 21 rule 46 CDD. That my property, this is my property. And if he has come late, no problem. He can come maintain the application under 2192 after depositing 5%. So that inning is given here. Then finally, certificate of sale is given to purchaser under 2194. Okay? This is the final certificate. This will give you right title interest if no objections are received, anything. Then delivery of possession of 2195. Judgment debtor का possession 95 and tenant का कब्जे में रहेगा तो order 2196. So tenant and all person claiming under him, a court will issue a warrant of possession. वो डिक्री के अंदर application order 21 rule 11 में mention करेंगे यहाँ पे. The mode of assistance sought is that this honorable court be pleased to grant warrant of possession, directing the judgment debtor and all person claiming under him to quit, vacate, hand over quite vacant, peaceful possession of the property to the purchaser. So if the persons are tenants in occupation, that this honorable court be pleased to order and decree the defendant to quit, vacate, hand over. Decree हो गया, warrant of possession be given here. ये लीजिए आप. अगर obstruction हुआ उसके बावजूद भी. Now you learn. Now come back to order 21 rule 35 36 में the court has passed a decree. Court has passed a decree for immovable property. हमने सीखी ना आपने. So now you are seeking to execute the decree against your tenant. 2136 की degree. You may not be going for attachment. Without attachment also you can go for a execution. 2146. So you are a landlord in the city of Bombay. In the city's small causes court file a suit on the various grounds, bona fide requirements subletting. Suit is decreed. Without going for attachment and sale, you can make an application for execution under 2111 or 2122. And if the application is allowed under order 21 rule 96, the court orders delivery. देखिए सर, अगर tenant कब्जे में नहीं रहेगा, tenant has created third party. If they may not be in injunction or maybe injunction. A third party say that no, the decree is not against me. The decree is passed by in favor of A against B. I am Mr. C. I am a subtenant having a legal right. Even before the suit, I have a legal right. Then when this is obstruction take place under order 21 rule 97, your remedy is the decree holder ki take out an application for removal of obstruction. देखिए 2198 के अंदर adjudication होएगा. This application should be filed within 1 month under the Limitation Act. Mansi, if you have got the Limitation Act, check करो आपके पास है. I think मैं बताया था already. Already I told you last time. It is a 1 month's time for removal of obstruction. Okay. Now that application should be tried like a suit under Order 21, Rule 101. देखिए, all questions to be determined. Now, whatever suit has been filed, application has been tried, 101 said, all question, including question relating to suits, interests arising between the parties to the proceeding on the application under 97, 99, or representatives and relevant to the adjudication of application shall be determined by the court dealing with the application and not by a separate suit. So this obstruction has taken place under Order 21, Rule 97. This is between the same parties or the legal representative. The court will decide this matter in the application itself and not by a separate suit. The court will lead evidence. Now the provisions of 101, 102, 106 तक लगेंगे आपको. This is the last proceeding here. This is a order is treated like a decree. Please note that the order the court which may pass final order under Order 21 Rule 101 is a decree. It's a decree which is appealable under Section 96. If a decree is passed by City Civil Court, come in appeal to the High Court. If the Small Causes Court has passed a decree, go before the Appellate Court. If the Civil Judge Junior Division, Senior Division passes, go to the District Court. So this is a decree. Please note that here. 104 के अंदर pending commencement such suits was the proceeding. How the application is heard is given procedure 105 के अंदर. The court can pass ex parte application if no objection taken. Like the application under 2157 के अंदर, if the objection is not raised, the court can pass ex parte decree. Please note that here. Now, when the court passes an order under Order 21, Rule 103, it's a appealable under Order 31, Rule RJC. Bombay के amendment के हिसाब से Order 43 के, this is a interlocutory order may be deciding, but यहाँ पे under the provisions of clause 10, there's a decree. Either you file under 93 or you come before the in AO under order 43 Rule 1 clause J. Bombay का amendment check करो आप Order 43. Clause J में check Order 43 Rule J. See, Bombay amendment says that yes, it has to be added here. R के बाद J आ जाएगा. There is amendment in 22nd. Calcutta में भी देखो, इसे Calcutta में भी it is a appealable order, Order 2157. Otherwise, you can go for a decree. There are two remedies given to you. So this is the end of execution proceeding today. Last 106, setting aside the ex parte decree application, like under Order 9, Rule 13, this is application, ex parte, on non-appearance, the court can pass order. The court has to hear it. So all hearing will take place under 101. Even the court having no jurisdiction can decide all matters here. Suppose a decree is passed by the City Civil Court Bombay, it can decide question whether the parties are landlord and tenant. If the decree holder takes up the plea, obstruction is, I am a tenant, he can decide that question. He need not send it to Small Cause Court. But there's a Bombay amendment to 101. According to me, the High Court, you have to make an application to the High Court, say Allahabad. Please see Bombay Amendment 101. 101 में Bombay Amendment है इधर?
Yes.
Amendment, yes, yes. There is a Bombay Amendment which says that you have to approach the court and the court will send the, suppose if it's a landlord and tenant question, the court will send the matter to the Small Cause Court. If it's a matrimonial dispute between husband and wife issue, the matter will be sent to family court. Please note that. If it is a issue raised between member and society, it may be sent to cooperative court. So that means the court would like to avoid the decree being executed by a court not having jurisdiction, because provisions of section 16, 17, 18, 19, 20, 21 CPC are followed here. Okay. Now this is the end of judgment. Now I discussed with you the two judgments which I mentioned yesterday. Now order 21 rule 82 padho aap. Execution order 21 82 kholiye. Order 21 rule 82. So when we dealt with the attachment of the immovable property, see what court may order sale. Sale of immovable property in execution decree may be ordered by the court other than the court of small causes court. Okay? You got it?
Yes, sir.
The
So also
the
8
court
minutes
of-
are remaining.
Yeah. 8 minutes are repairing. The court of small causes court cannot execute the decree. That is what the judgment of Mahadev's case. That is open Mahadev's case. Dekh lijye. Judgment of Mahadev. किधर है महादेव का केस? आपके पास है महादेव का? You read the case now? Yes, Mahadev's case record. That is AIR 1981 Supreme Court, page number 416. Here the decree was passed initially by the Court of Small Causes Court. And the Court of Small Causes Court passed a decree for certain amount, then it transferred the decree for execution. The paragraph number 6 के अंदर है, the judge of the Small Causes Court, वो देखा, ये decree was transferred to civil court. वो civil court ने क्या किया है? The transferee court under the provisions of section 42, it has the same powers as the executing court. Please note that. Remember section 39 and 42. Under 39 and 42, executing court has a similar power, section 42 CPC. वो 42 के अंदर ये सिविल कोर्ट ने प्रॉपर्टी अटैच कर दिया. ये प्रॉपर्टी अटैच किया तो the contention was raised, paragraph number 7 के अंदर है ये. Attachment was done by the civil court. Then paragraph number 8 में देखिए, against the judgment of the learned single judge, the attachment was challenged. Okay, the decree of the small causes court which is transferred to transferee court under 42 cannot be attached under order 21 rule 82. The trial court rejects the application, appeal court allows the application. The high court rejects the application. Then the matter travels to Supreme Court. The Supreme Court gives the finding here that here, following the judgment of the Supreme Court in the case of Paswan's case, that is Kiran Singh versus Chaman Paswan, paragraph number 31, it says that it is fundamental principle well established that a decree passed by a court without jurisdiction is a nullity. Nullity and its invalidity could be set up whenever it is sought to be enforced or relied upon at any stage of execution. So यहाँ पे execution के stage के ऊपर the decree passed by the small causes court transferred to civil court was challenged that under order 21 rule 82 there is a bar. The immovable property cannot be attached of the small causes court. So there is an inherent lack of jurisdiction, because in the case of Chaman Paswan's case, that was the matter. From Patna court. In the lower court, the gentleman filed a suit in the Munger court. In the Munger court, for eviction of a defendant on the ground is a trespasser. The trial court took up the plea that he is not a trespasser, he is a tenant, he is protected. So the suit was dismissed. Then the appeal was carried, appeal also dismissed. Then after dismissal of the appeal, the plaintiff went to second appeal in the High Court under section 100. In the second appeal, the High Court registry took objection that the amount which was paid on the suit was a small amount, a lesser amount and not the marketable amount, court fees amount, there was a defect. Under section 9 of the Court Fees Act, Mansi, you got see that section, kindly see section 11 of the Suit Valuation Act. Section 11. Under the Suit Valuation Act, the objection could have been raised even at the appellate stage. It is like section 21. This is the objection. The plaintiff himself who filed the suit took objection. Now I have paid more court fees. If a more court fees is paid and the appeal filed to district court is not correct, it should have been filed in the High Court. The decree passed by the appellate court is therefore null and void. The Supreme Court did not agree with the contention. You are a plaintiff. You yourself raising objection jurisdiction. You cannot do that. In fact, the defendant did not raise objection, nor in the trial court, nor in the appeal court. Now, only when the High Court, the matter is reached under second appeal, when the office tells you that you have to pay extra court fees, and there is no prejudice against you. Full-fledged trial has taken place. Under the provisions of section 11, in order to set aside, there must be substantial prejudice. The Supreme Court said, what is your prejudice? That is the language used in section 21 of the Code of Civil Procedure, if there is no provision. But Chaman Paswan's case come into play when the court having totally lack of jurisdiction, like the Small Causes Court has no jurisdiction to pass a decree for under Order 21 attached immovable property. Similarly, Small Causes Court cannot try a suit for specific performance or a partition suit. Chaman Paswan ka judgment dele yahan pe, that is a paragraph, relevant paragraph is Chaman Paswan 6, paragraph number 6 ke andar. That is the observation of the Supreme Court following one of the earlier judgment, Kiran Singh's case. So please note that the objection cannot be taken out unless the court is inherently lacking jurisdiction. Mean the matter which should have been tried by the family court, decree cannot be passed by Small Causes Court. Suppose if the plaintiff and defendant are landlord and tenant, they fall in love, they get married. You cannot go for a decree to Small Causes Court that parties are landlord and tenant, grant a decree. Small Causes Court entertaining that yes, parties are landlord and tenant, under 33 I can pass a decree. That decree is invalid because under section 7 of the Family Court Act, the court has exclusive jurisdiction. Wherever the words is used, notwithstanding anything contained elsewhere in this act, that particular court has exclusive jurisdiction. The decree cannot be passed by any other court. If a decree is passed, it can be challenged at any stage. But whereas if the two courts are having jurisdiction, dual court, Bombay Court and Delhi Court, if you have not taken objection, the Delhi Court decree is valid. The objection should be raised at the immediate stage before filing written statement, before the framing of the issues, or in the appellate court before the admission of the appeal. A belated admission cannot be. That is what section 21 says that here. So either by consent the parties cannot confer jurisdiction. Both the parties cannot agree to that effect here. So in the case of Kiran Singh's case, the gentleman plaintiff himself has filed a suit. He cannot raise objection to jurisdiction. How can the plaintiff who has filed the suit and raise objection that the court has no jurisdiction? It is highly improbable. It cannot be allowed. It is only the normally defendant raises objection or the court raises objection. Here the High Court under second appeal under 100 and section 100 raised the objection that the court fees is not proper. He paid the court fees. He says, if when I pay the court fees, the district court will lose the jurisdiction. Then so what?